We continue to read the divorce case of Mr. Vincent Guthrie and Mrs. Dorretta Guthrie, husband and wife, divorcing. Should the claimant, Mr. Guthrie, succeed on this claim, that's the claim that Mrs. Guthrie withdrew money from their joint accounts and she need to pay it back, but Mrs. Guthrie was saying that her withdrawal were justified. She spent the money on their daughter's illness and to pay for the construction of their house. Let's see. It is said, joint bank accounts sound so lovely and cozy, don't they? A physical manifestation of a couple's unity. A declaration of mutual trust in a shiny pair of his and hers cash machine card. Nothing says what's yours is mine, but what's mine is yours. Quite as much as pooling your resources, especially if you earn double what your partner does. The fact is that one can have a joint account with anyone else, but once persons are jointly on that bank account, once the papers have been signed off, then unless special conditions are imposed upon the operation of the said account, both parties have 100% rights to that account. No matter who started the account or who put in more money, in the eyes of the law, both are equal holders. Right? So, equal holders of that account. The result of this legal truism is that account co-holders enjoy the right to spend, give away, or transfer funds to other accounts without the consent or knowledge of the other account holder. There are cases in which the wronged in quotation mark, the wronged party may get back some of the money, but legal action is required to establish that the withdrawals have been in breach of the conditions on which the account has been established. So you see that. Be careful about making joint accounts, especially in the context of affairs of the heart. Be careful. Anyway, we continue. Although the parties here separated in 2006, there has been no evidence in the affidavits of the claim that the withdrawals of which he complained have been effected in breach of any condition on which the accounts or any of them has been established. Accordingly, I would hold that there is no basis upon which the defendant ought to be required to account to the claimant for any sum so withdrawn from any jointly held account. So you see what this is saying? Is that when you and somebody else open a joint account, the only way you can take legal action in a case where that person withdrew money, it would have to be proved, you would have to prove that it was in breach of the conditions of the account. Alright? So, there you have that part of it. We continue. We're going to look at this case as it relates to liability for jointly held debts. The claimant, Mr. Guthrie, also seeks contribution from Mrs. Guthrie in respect of their jointly acquired debts or obligation. It is trite law that where parties have jointly acquired debt obligations, then they are jointly responsible for the discharge of such obligations. So here, they are jointly responsible for paying back the money. The question here is whether there is evidence to support the claimant's assertion, Mr. Guthrie's assertion, that there are such debts and that the defendant, Mrs. Guthrie, should share in their discharge. In the instant case, Mr. Guthrie alleges that Mrs. Guthrie should reimburse him for funds in respect of credit card payments purportedly made on her behalf. So he made credit card payments for her. He said he was left to continue to meet our jointly acquired debt inclusive of credit cards and loans. For example, he refers to an outstanding loan regarding the property at Pitcairn, the balance on which he said stood at $1,350,058. Let me see. $1,350,860.73. And he exhibits a document which purports to be a schedule showing how a $2 million debt is to be repaid. Alright, so you're looking at jointly held debts by both husband and wife. Alright, continue. It must always be remembered that he who alleges must prove. It is therefore Mr. Guthrie's burden to show that there were in fact jointly acquired debts. As far as the claim for credit card payments are concerned, Mrs. Guthrie denies using the credit saved for the purpose of securing medication for their daughter Shanique. In any event, no specific evidence of ascertained sum is given by Mr. Guthrie, and insofar as the claim for credit card payment is concerned, that claim also fails. So he had failed to present documented evidence to the judge. One of the allegedly outstanding debts in respect of which contribution is sought by Mr. Guthrie is fees due to the law firm Crawford, Miller and Company. However, it should be noted that the defendant, Mrs. Guthrie, had clearly demonstrated by her final affidavit that there is no outstanding debt to the law firm, it having written off the outstanding debts due for legal fees. In his first affidavit, the claimant, Mr. Guthrie, mentions that he took a loan from the Jamaica Teachers Credit Union in the amount of $2 million. It is not stated in that affidavit what was the purpose of that loan. In his second affidavit, he speaks of the outstanding loan regarding the property of Pitcairn, to which I have already referred above. In his fifth affidavit, he asserts that the balance on the loan at the end of February 2011 would be $1,243,591.95. It would appear, though, it is by no means clear that a loan was taken by Mr. Guthrie against land at Sheffield in order to be used in the construction at Pitcairn. on the Mr. Guthrie's own affidavit evidence, that loan was taken on August 3, 2006. The evidence which has been adopted does not make it clear when the parties actually separated and whether it was before August 3, 2006. So the question here is, did Mr. Guthrie take this loan before the couple separated, or was it after? Continue. Notwithstanding that, it is also clear that the construction of the home at Pitcairn is still not complete, and that has implications for the order that I should make. I accept that there is, on a balance of probabilities, an amount outstanding in relation to construction at Pitcairn. And I also accept that the loan of $2 million taken out was with a view to that construction. The defendant, Mrs. Guthrie, must therefore bear some responsibility for that loan. In the light of the findings which I have made above, I make the following orders. Alright, we will look at the orders in our next video.